Nani anaandika? Mtete. Anaandikia hapo hapo.
Yes. Thank you, members of the fourth estate. Now, yesterday, 25, a petition was filed before the Public Service Commission by one Hussein Aila, requesting the Public Service Commission to take action against the Director of Public Prosecutions, whose current office holder is Mr. Renson Ingonga Mulele. And in that petition, there has been a number of allegations that have been made against the current Director of Public Prosecutions, which, of course, revolve around the decision that was made by the Director of Public Prosecution, February 2026, where the Director of Public Prosecutions made the decision, the independent decision, after reviewing the evidence and the case that was before the Magistrates Court in Milimani, and decided to have the charges against one Farida Idris Mohammed withdrawn on account of those charges having been made in the year 2023, which, in his view, after assessing the facts, amounted to an abuse of the process of court. Now, it is important, because my senior, Mr. Danstan Omari, is going to at least give you a background of the facts. It is important that we disabuse ourselves from a misunderstanding that the petitioner has presented before the Public Service Commission, which, of course, he aims at misleading the Public Service Commission so that they can cause the removal or begin the process of the removal of the Director of Public Prosecutions from office. Now, in the petition filed before the PSC, two main grounds or major grounds have been proposed. One is that of incompetence, and secondly, is that of gross misconduct. On the question about the Director of Public Prosecutions having grossly misconducted himself in discharge of his powers, it has been alleged that the independent decision that has been made by my senior Renson Ingonga has been made in violation of the Constitution, and therefore he's acted grossly. And one thing that has been alleged is this, that the decision that was made by the Director of Public Prosecutions to withdraw these charges has been motivated by ill will, that there has been preponderance of evidence presented before the court to suggest that indeed the person against whom the charges have been presented before court is actually guilty of those offenses. But one thing that the petitioner does not understand is this: the style or the manner in which the business of the Director of Public Prosecution or a holder of that office is conducted is one that is prescribed by law. Article 157 of the Constitution prescribes the powers and the functions of the Director of Public Prosecutions. Number one, he has the power to institute criminal charges. Number two, he has the power to take criminal charges from the person who commenced either privately or otherwise criminal prosecutions. And number three, he has the power to cause or begin the process of terminating criminal charges against any person. In the power or the decision made by the DPP to terminate criminal charges, that is not a power or a function that is done independently. This is a function that is done after the court has authorized the Director of Public Prosecutions to enter what is previously or was previously called nolle prosecute. And when the Director of Public Prosecutions decides either to take up criminal charges or to commence criminal charges or to terminate criminal charges against any individual, this decision to charge or to terminate is made pursuant to either the evidential test or the public interest test. So this therefore means that sometimes even when there is preponderance of evidence, there is evidence suggesting that someone might have committed an offense and is therefore liable for prosecution, the Director of Public Prosecution is by law sometimes precluded or prevented from taking action against that suspect or that accused person because of the public interest test. So to allege, as it has been alleged by the petitioner, Mr. Hussein, that the public prosecutor, Mr. Ingonga, is guilty of misconducting himself because he has made the decision, which of course was not favored by the court, to terminate the charges against Farida Idris, is actually made improperly, so that in the fullness of time we shall be defending the Director of Public Prosecutions and trying to illuminate the mind of this petitioner that in fact he has been misled to filing the petition before the Public Service Commission, and there is no merit whatsoever in the petition. The public needs to be informed of the test that is there, the test that is used by the public prosecutor or Mr. Ingonga while taking up or terminating charges. In fact, and I want to rest at this case that is in issue, that has provoked the filing of the petition before the Public Service Commission by Mr. Hussein Aila, is not unique. It's not the first one that has been terminated or withdrawn by the public prosecutor. In fact, last year alone, approximately 1,000 cases were terminated by the Director of Public Prosecutions. This year, there has been a number of cases, and this one is not unique on its own. So to allege that by the Director of Public Prosecution exercising his powers independently, as it is so required under the Constitution, is acting either incompetently or acting in violation of the Constitution is at the very least unfortunate, and we are hoping that in the fullness of time, the counsels representing the petitioner will advise him accordingly, so that he is advised that the petition that lies before the PSC is dead on arrival. Thank you.
We have instructions to act for the Director of Public Prosecution, one, Renson Ingonga, on two matters. One, to deal with the petition at the Public Service Commission, which my learned colleague has laid bare the angles that we are going to take. Number two, two media newspapers, the Daily Nation and the Standard, carried a story that is not factual. We have instructions to do a demand letter to them for them to correct the wrong information that they have given the public. One, the case number E2222/2023 has not been withdrawn. An application by the Director of Public Prosecution to withdraw was dismissed yesterday. And the court, the trial court, ordered that the matter to proceed expeditiously without delay on the 27th day of May 2025. So it is factually wrong for Nation newspaper and Standard newspaper to say that that matter has been withdrawn. We have instructions to take up legal action against the two media houses. Number two, the Director of Public Prosecution exercises power to withdraw. This is a case involving a love affair, a family affair. Therefore, to preserve public morality, the Director of Public Prosecution decided to withdraw this matter. Husband and wife, love gone sore. Two, the Director requested that this matter be withdrawn because it has been litigated up to the Court of Appeal in civil matters. The court has declined the request of the Director of Public Prosecution. Free. This Office of the Director of Public Prosecution annually presents its report to Parliament. And among the requirements that are needed for the Director of Public Prosecution to provide to Parliament is the number of cases he has filed in his office and the number of cases he has withdrawn. 2020 to 2021, the Director of Public Prosecution charged 477,572 people. 477,572 people. He withdrew in 2020, 2021, 2,572 were withdrawn. 2021, 2022, 317 cases, 885 were filed, 2,119 were withdrawn. In 2022, 2023, 292,483 were filed. The Office of the ODPP withdrew 2,199. In 2023, 2024, 298,610 cases were filed. To date, the year analysis is going on, already more than 1,000 cases have been withdrawn. So this is a report presented to Parliament. This has been debated and Parliament has adopted it. The power to withdraw is a constitutional power which cascades to the statute called the Criminal Procedure Code, Section 87A, where the Director can withdraw the case depending on the policy called the decision to charge. So, it is factually wrong on the two media houses. It is not in good taste. We know there is a big war to demonize public officers. The Director of Public Prosecution shall defend his office and shall defend his position and shall defend the decision to run his office without anybody's undue influence. The Director of Public Prosecution under Article 157 cannot be directed. He cannot be influenced by anybody. Therefore, he is exercising the mandate he was given to have. Those are the instructions we have from the Director of Public Prosecution. In a short while, we shall be sending to the media the two houses that demand notice. And we shall be moving to court expeditiously if they don't retract what they have factually reported to be wrong. Thank you very much. Unless there is a question. Is still on. It is coming on the 27th of May 2025. The matter is proceeding. The application for withdrawal was dismissed by the court. Any other?
So the matter that was pending